Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business to help educate you on complex legal terms in an easy to understand manner, to help understand why you need to do certain things in your business from a legal point of view, and to help you develop a plan for the future. Our mission at Business Legal Lifecycle is to help empower all small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place. Did you know that any business owner is on average 7 months away from losing everything? That is the average time it takes from a successful business to fold when an aspect of their business is not set up correctly. Have you ever wanted to get legal advice but didn't understand what was going on? Do you feel like there is a divide between lawyers and their clients? Then this TV show is for you. It is all about empowering you and your business with the knowledge and tools to ensure that this doesn't happen to you. Business Legal Lifecycle TV delivers a twice-weekly show focusing on the legal aspects of your business. At lunchtime on Mondays, we present Fast Fix Monday, a quick 5 to 10 minute show that will give you some actionable steps to consider for the week for your business. And at lunchtime on Wednesdays, we present our in-depth show of between 30 minutes and an hour, where we go through complicated legal aspects of your business in a simple to understand, plain English manner. And whether that is through educational pieces or interviews with experts in their fields.
Afternoon, everyone, and welcome to Business Legal Lifecycle TV. Today is Monday. I was thinking about something else then, and I was slowly tapering off into something else. I apologise for that. Today is Monday, so it's Fast Fix Monday. So this is where we go through a topic relatively quickly, give some tips to our viewers or listeners. And as always, if you've got any questions, please let us know, or any comments you want to make. I'm here, and also Jeremy's here. Say hello to everyone, Jeremy.
Hi everyone, hope you're having a great day.
Excellent. So today we're talking about what to look out for if you were going to write your own will. If you listen to the previous shows this month, we're talking about estate planning and retirement. As part of that, writing a will is important. We'd encourage everyone to potentially not write their own will if they can avoid it. If they can't, then need to follow these sorts of tips that we're going to outline today. But we'd definitely say that this is the sort of area you need to talk to your consultants about. So, Jeremy, do you want to kick off with the first thing to look out for when you're writing your own will?
Yep, absolutely. Thanks, Craig. So the first one is guardianship of children. So if you have children, you need to make sure that if something happens to you and your spouse, that you have thought about what will happen with your children. Who's going to be their guardian? This is one of the reasons why it's a great idea to have a lawyer write your will, because there can be various things to think about. But you need to think about the following things: similarities with your lifestyle, values, and if you have religious beliefs, those. Who your child might be and who they might already have a bond with, whether they have got any sort of planning or any historical planning to do with the financials. So you really need to have a think about practically who the right person is for that role, and then have a chat to them. This is, as I said, one of those areas where, as Craig said at the beginning, and we're going to say this for a few things, that you should get advice and make sure that your will is drafted properly. But if you choose to do your own will, just make sure that you've thought about who the guardian is and that you've thought about all those bits and pieces. Craig, number two.
Yeah, number two is assets. So that's working out what assets you actually own. We encourage everyone to list those out, and perhaps if you can, put values next to the assets. And if there's any mortgages or loans that are associated with that, put the values of that as well. It's important when you're looking at your assets, something such as your house, you need to determine who actually owns the property or how it's owned. So a lot of times if you've bought it with a partner or someone else, there'll either be joint tenants or tenants in common. So joint tenants means it automatically goes to the surviving person. Tenants in common means that you can gift your part of your property to someone else. So you might own 10% or 99% or 50%, whatever it is. But it's important when you're writing a will to look at the assets and work out what you own and what you can gift in your will. Number three.
Number three is to think about the cherished items. So when you're considering your assets, make sure you don't overlook the smaller items. Such items may not be significant in value, but they might have intrinsic, personal, or emotional value. So when you write your will, you need to have a think about, if you have got specific gifts, what do you want those things to go to? Sometimes you don't put that in a will, you do that in what we call a letter of wishes, to basically tell people what you want to actually do with those precious items. Craig, number 4.
Number 4 is appointing an executor. So this is one of the most important things to do when you're drafting a will. The executor is the person that basically does what you ask them to do in the will. So they will step in, organise funerals, those sorts of things, sell assets, get it all together to give to the beneficiaries. So it's quite an important role. And due to that importance, when you're making a decision about who it's going to be, you need to make, consider different people, where they live, their experience, those sorts of things when selecting someone. It doesn't have to be a family member. It could be someone outside of the family. They don't have to be beneficiaries, those sorts of things. But definitely need to think about it. And if you are appointing an executor, you should also think about potentially appointing a secondary one in case something happens to that person. It's very important when you're drafting your own will, or even when you're talking to someone about them drafting a will, is picking someone for the executor and making sure you're comfortable with that person. Not that you're going to be around, but you obviously want them to do what's best for your beneficiaries. So that's number 4. Number 5, Jeremy.
Number 5 is the beneficiaries. So these are the people who are going to receive the benefit of your estate. So that could be people, it could be charities, it could be organisations. So you need to have to think about who gets that money, and if there's anything left over, who gets what we call the residuary of the estate. So have a think about that. If you are going to exclude a beneficiary, so excluding a child, then you really need to think about talking to a lawyer to make sure that's drafted properly, because that is an area that gets challenged all the time. So thinking about your beneficiaries is number 5. Craig, number 6.
Excellent. Number 6 is about giving to charities. So if you want to include a charity and giving them a gift in your will, you obviously need to have it in your will. A number of charities have specific wording that they require to be in a will when there are bequests to them. So most of them will have it available if you contact them, but it's important to look into it and make sure that if there is the particular wording that the charity requests for any gifts in wills, that you follow that and put that into the will. So if you're looking at giving it to charities, you don't want that gift to fail. So make sure you look into the wording for gifting to charities. Number 7, Jeremy.
Number 7 are your funeral instructions. Now, often you won't put all of the instructions into your will. We would recommend not doing that. But you want to make sure that you've set out the instructions of what you want to happen for your funeral. You may put in your will whether or not you want to be cremated or buried. So you need to have a think about that. And then also write out the instructions for your funeral, if that's what you want. Some people may not want to put the instructions for their funerals, but if you do, then you need to have a think about it at this point in time. Craig, number 8.
Number 8 is about managing complex circumstances. So as Jeremy said before, if your life is a bit more complicated and there's some complexities in regards to family, financial circumstances, or you have a business or a company or something along those lines, then you need to make sure that you're outlining what's going to happen in those circumstances. So again, this is not something that we'd suggest you do by yourself. Definitely want to be talking to a solicitor when you're doing these sorts of things. If you're excluding someone, for instance, you need to make sure that you've got the right way of phrasing that. If there's any previous marriages, divorces, etc., you need to make sure they're taken into account. If you have self-managed super funds and there isn't a nomination, you want to make sure that's correctly outlined, as well as if you're a company director, you want to include those sorts of things in the will when you're writing it yourself. So if there's particularly complex circumstances, you need to consider those. And again, given the complexity, we'd definitely be suggesting that you're talking to your solicitor or other consultants at that stage. Number 9, Jeremy, which goes in nicely to consultants.
Yeah, so number 9 is to include the details of your accountant, financial planner, and your lawyer if you've got one. Make sure that you've got their details so that people know who to talk to. So often, we've seen people who've passed away who haven't left those details and no one's known where to go and get their information from. And so just include the names and contact details for those people. So that's number 9. Craig, number 10.
Yeah, number 10 is about a different document to a will. It's an enduring power of attorney. That's normally done at a similar time when you're preparing a will. And that's where you appoint someone that can make decisions on your behalf in relation to health and personal matters and also financial matters. So health matters can't be made unless you've lost capacity, but you want to have someone that you obviously trust and be able to make the right decision by you. This is when you're still alive. Once you pass away, your enduring power of attorney ceases, and then your will becomes a document that governs how your estate's to be distributed. So enduring power of attorney, like with the executive, you're appointing someone that you want to trust. You want to look at where they are, what the life experiences are, those sorts of things, because potentially they're making some pretty important decisions on your behalf, in your best interest, of course, but it's health and also financial decisions. So when you're preparing a will, you'd normally be looking at an enduring power of attorney as well. So that is the 10 things, Jeremy.
Yeah, that's it. So thank you for watching or listening if you're listening to the podcast. As always, please like this video on Facebook. If you haven't already, please like our page. You'll be able to get our content twice a week. We have show notes, as always, for this episode. That's at businesslegallifecycle.com.au/112 for show 112. Thank you very much for watching. We'll be back on Wednesday with another interview long-form episode. So we'll see you then. Thanks very much.
Thanks, everyone. Bye.